earlier in this program, we had a conversation on the important ruling from the Supreme Court that was to be made at around 10 o'clock, and that indeed has been made. And we have one of the advocates who was quite close to this particular case, and the Supreme Court was delivering a ruling addressing the question on whether a judge appointed to serve in the Land and Environment Court can sit to hear matters in the High Court, such as criminal matters. And I have in studio for this conversation, this particular conversation, to give us a context, Tokero Lekina. He's an advocate to the High Court, and if you probably remember, that name it sounds good. It's a really good name, but during the IABC selection process, he was definitely atop of the candidates there. Thank you for joining us for this particular conversation. First of all, what was decided by the Supreme Court?
Thank you very much. What we had at the Supreme Court was an argument that originated from some criminal cases in Malindi. Some people had been or were charged with various offenses. These ones particularly were related to robbery with violence. In 2013, towards the end, the then Chief Justice, Mtunga, decided to empanel judges to hear some criminal appeals. That was what was referred to as the Judicial Service Week.
And that was to fast track?
And that the idea was to fast track those cases. Now, the trouble is, he empaneled also judges from the specialized courts of the Environment and Land Court and Employment and Labor Relations Courts. Now, the jurisdiction of all these courts is very specific, and these judges from these other specialized courts do not have the jurisdiction to hear criminal cases. Okay. And our argument in the Court of Appeal, in the High Court, was that they did not have jurisdiction to do so. It was overruled in a decision known as Matende versus Republic, and those cases then went to the Court of Appeal. There were 3 cases that were consolidated. I was acting for one of the appellants. Another colleague of mine by the name Aoko Otieno was acting for another one, and Gumbao Mutua was also acting for one of the accused persons. We successfully challenged the decision of the High Court to in that particular bench.
But this was still back in 2013?
This was in early 2014.
2014, right.
Then our appeal was heard in Malindi, and the Court of Appeal agreed with us, said that Justice Angote did not have the jurisdiction to sit as a judge of the High Court. He is a judge, he's a good judge, very competent, but his appointment was to the Environment and Land Court, and he could not reach out from the from the Environment and Land Court and deal with criminal cases in the High Court.
They heard you, but were you content at that point, 2014?
We were very happy ourselves,
right?
But the DPP was unhappy. Then he petitioned the Supreme Court. Mm-hmm. When he petitioned the Supreme Court, we cross-petitioned on the issue of representation. Because you see, under our law, under the Constitution, a person, an indigent person, that is a poor person who is charged in a criminal, with a criminal offense, a serious criminal offense, and he cannot afford representation, is supposed to be given a lawyer by the government. And that's what we usually refer to as pro bono.
Yes.
And we talked about, in our view, there has to be effective representation. So it's not the pro bono scheme that exists now does not really guarantee that effective representation. Right. So we cross-appealed on that point, and the court felt that that is a decision that they will hold their hands on at the moment. All right. They want that issue to be dealt with at the High Court level, because what has happened is basically that all those appeals that were heard by those judges would have to be reheard. Okay. In the High Court.
But that decision was held, you say, in 2014, and has been held to date?
Yes,
until the decision.
No,
was
what
made
we
today.
did when they came to the Supreme Court, because the judges in the Court of Appeal, what the judges had said was that the cases go for retrial.
Yes.
So they applied for a stay, which we conceded because we did not want to waste time dealing with the issue of stay. We conceded to the stay.
Okay.
The decision has taken a long time, in fact, coming. It was very long coming. But it came out today. And
what was that decision, if you may actually read?
Yeah, the decision basically, it's actually it's a 61-page judgment. It's very detailed. But essentially what the judges, which this is probably the part that will interest the public most, because what they say is in paragraph 114, it therefore follows that in the light of the terms of Article 2, sub-Article 4 of the Constitution, despite the drawback our decision will have on the backlog of cases in our courts, we have no choice but to accede to the respondent's plea that their appeals at the High Court level be reheard. Our decision must of necessity have a similar effect on all the appeals that were determined by similarly empaneled High Court benches.
So what does this mean in terms of those judges who sat in the Land and Environment Court and could still hear criminal cases in a High Court?
No,
now
they didn't have the jurisdiction.
Okay.
And moving forward, that will not happen again.
All right.
Unless the law is changed.
All right, let me bring in two professors, that is Professor Peter Kagwanza and Munene Macharia, who was with me earlier, just on your observations on this particular ruling, and given the hindsight, I mean, what we've been given as context by Tokero Lekina, how you receive this. I'll start with you, Professor Peter.
I think one of the things we have to appreciate is the goodwill that Chief Justice Mutunga had to basically unclog our judiciary and get things done, quickly to dispense justice for the country. But I think the problem here are the instruments you use in order to do the same without basically infringing on the goals or intentions of the court, which is to provide the highest level of expertise, so that justice is not just done, but seen to be done by the best people who can do it. Now, the moment you unbundle, different sectors and merge them into a kind of a Roy-Com choose mix of some kind, then you have a problem here, because you're compromising the question of quality, and that quality has much to do. And I think that's what the council here.
So a good precedent moving forward.
Good precedence is that we need to, and this is not just about judiciary. It applies to all sectors of society, that let's keep expertise clean. In the universities, if we're talking about the Department of History, Department of Political Science, Department of Medicine, I mean, let's have the best Kenyans doing what they are best at. Let's not try to cut corners and bring things that don't work. Otherwise, you'll meet the Olekinas of the world, and they'll challenge you on those cases.
That's right. And Professor Macharia, I mean, this is, we're talking about it because it has some, ramifications for the Kenyan.
Yes.
Which is of most importance, and that's why we're here. But how do you receive this particular, ruling?
It's a powerful ruling. It's precedent setting. And the message being passed out, the right people should be doing the right thing. You don't mix up beans and maize.
Well, Githeri is good.
Although we know you can do it in Githeri and you'll be satisfied.
Yes.
But I think it's a very important ruling in pointing out that maybe some injustice was inflicted on people because the wrong people are listening.
Okay.
So the emphasis that judgment should be done by the right people who are there for that particular part. You don't go fishing somebody from somewhere. You look as if you can be a judge. Be here,
yes.
Listen to this thing. In that sense, then, it is a very important ruling for the country. Congratulate the Wakili for the good effort, because he's been persistent on this for some time.
Yes.
But it has other implications. Now, in case some people are convicted by the wrong judges, should they now be released?
That's a good question to put to Tokero at this point.
Yes.
And those who are released by the wrong judges, should they be brought in?
Yes, we can get the legal representation of the facts. Yeah.
Yes, that is actually the effect of the paragraph that I read to you. The judges said that it is going to have a ripple effect. People may have been convicted, or they may have been released, and that happened where you had an incompetent bench sitting. And if an incompetent bench sat, it means that the judgment was a nullity. And if you are released, it's up to the state now to choose whether it's going to go and recall those people or not.
Yeah.
It's really up to the state. But
if you're convicted, what's your recourse?
Who are convicted,
yes,
they will have a right to be heard again in the High Court.
Yes.
The other effect of this judgment, which is actually even more profound, is that the architecture of the judiciary in Kenya has now been defined, and it is settled that you have judges who have applied and who have been employed to work in the Environment and Land Court. You have judges who have been employed in the Employment and Labor Relations Court, and you have judges who have been employed in the High Court. That is the job that you applied for, and that is the job you shall do. There is no cross-cutting in this particular sense. Of course, there are challenges, because there are some cases that cut across. If you're dealing with a mortgage, for instance, it can be dealt with as a commercial transaction. But if it can also qualify as a land issue, because it deals with land. The other effect, of course, is that under Article 162, Subarticle 2, the Environment and Land Court issues and employment and labor relations issues can only be heard by those superior courts. The magistracy cannot handle land matters. And this has been true from the inception date of the Constitution.
It definitely means
from the 27th of August, 2010, when the Constitution passed. That is what Wanjiku wanted. Wanjiku wanted that those jurisdictions be separate but equal.
So the cases will be more thorough?
Of course, because you will also have expertise in those cases.
You mentioned something that got someone, I'm sure it got someone's heart pumping a bit faster, and that's for those who are released, and the state will seek you out. Is it foreseeable? I mean, will they actually, can people expect that?
I mean, victims also have rights.
Right.
And they must, even under the Victims Protections Act, they also must, the state should ideally ensure that if somebody was wrongly acquitted by a bench that did not have the jurisdiction to do so, they should follow that person and get him tried. He might as well be acquitted, but properly.
Okay. And just,
would there be an issue of double jeopardy?
Since it was a nullity, there is no jeopardy.
I mean, to the person who was released, he went through a process, a legal process. It may be.
It was an illegal process.
But then it was recognized as legal.
No, it wasn't, because it was challenged from day one.
It was just a stay on it.
It was basically what happened was that in fact, even before those cases hit the courts, I had already written to the Chief Justice and told him that what he had done was unlawful. And if he had paid attention to what I had said to him at that time, which was basically that we have the Commissioners of Assets Act. It has not been repealed. It empowers him and the Attorney General to go to the President and tell the President that we have a big backlog of cases here that we are not able to handle. Please appoint judges, appoint some commissioners. And this had been done before. Like you remember, there's a time when we had Tutui. She was a commissioner of Assets. Lady Justice Kaminwa, the deceased, was also she started as a commissioner of Assize and she went on to become a judge. So these things are done.
There's an alternative then for the former CJ and more alternatives for our current CJ.
Even our current CJ can apply that if there's a backlog of cases.
Okay.
And in fact, the other effect of this judgment is that I think they would, Parliament will have to look at the Judicial Service Act. Presently, the number of judges is fixed at 154.
Yes.
I think they need to look at that, because ideally each county should have a judge of the High Court, a judge of the Environment and Labor Relations Court, and a judge of Employment and Labor Relations, and of course the Environment and Land Court.
All right, let's put this issue to rest, and something that we can all weigh in on is the preparedness for the elections, and the IEBC preparedness for the elections. You were running for that particular office in terms of being the chair.
Yes.
Chebukati went through. Seeing what he has done so far in terms of preparedness, would you have done anything different?
First of all, I would like to congratulate him on his appointment. I think the president had the choice, and he chose him. It was his right. He had a constitutional, legal right to choose, and he chose him. What would I have done differently? Maybe right now there are so many issues that are coming up.
Yes.
And there are a lot of those tenders that are being cancelled, the ones that had been published, and people had gotten those tenders. I think one of the things that we had said was critical to running a free and fair election was that a proper audit of the work that had been done so far by the IEBC required to be done. And that will have enabled anyone who is sitting in that position to look at what the gains and the gaps, and to try and fill them. And there is also the issue of meeting the people and talking to them about the processes, agreeing with them on how to move forward, because they have a great stake at what is going to happen. It is not possible. My view is that the IEBC is a very, very important institution.
Yes.
As we saw in 2007, if you do not have very decisive leadership at the IEBC, you are going to have bloodshed.
Right.
And it is important that we should look back every time, and I'm sure that the IEBC, as presently constituted, is also perhaps looking back to see where the problems were and make sure that they rectify them.
Right.
The High Court actually made quite some of the decisions, like the one that was made on the pronouncements of the results at the constituency level. I think that is a good decision. It's going to, in my view, I don't see why those results are going to be deemed to be provisional. What can be done to those results apart from adjusting them if they are going to be announced in Nairobi? I think if we follow what the law is and we try to apply it without quite dispassionately, we will have a good election.
And that's what we all hope for. Professor Kagwanja and Munene, in terms of preparedness, things he's pointed out that would have been done differently, what are the red flags or perhaps points of concern in terms of preparedness?
I think we need to treat IEBC as an institution. And those who've worked with bureaucracies, including what we'll be discussing as the High Court or the judicial system, systems are systems, institutions are institutions. And sometimes they are divorced of the people who are presiding over them. They have a life of their own.
Right.
The strengthening of those institutions is what matters. The debate we are having in Kenya about IEBC is a very convoluted debate. Debate in the sense that we are discussing personalities rather than the institutions. Whether we have these 7 commissions today and we had them yesterday, the institution is the same and it was working within a certain program. So it is a question of how far had the previous commissioners gone in terms of preparation, and from there, how far have the new commissioners gone? So that if they're not moving as fast as they needed to, then we take issues with them. And I think that's what the council here is saying, that we needed to first of all to have taken audit and known what had been done and what is being done now. I don't think there is a cause for worry in that regard. That's one. We invited, by we I mean the Africa Policy Institute with our partners in the UN, invited the chair of the Ghanaian electoral management body.
Right, to learn a few.
Yes, and she came over here and addressed us. We actually made it sure that she addressed Kenyans, so we had 2 hours of her to speak about why she successfully ran one of the most peaceful elections, and when we have one of the most unruly politicians on the continent. They are in Ghana.
Yes.
I don't want the Ghanaian ambassador to hear this.
Yeah, and some of the lessons, just quickly,
the point she made, which needed to be reiterated again and again, is that we need a commission with teeth that can make decisions and people see that it is making decisions. Being a judge, being a referee, being a mediator does not mean that you are woolly. You have no backbone.
Yes.
You need to have a backbone, and there must be consequences for the decisions you made.
All right, sorry to cut you short. I need Professor Munene to weigh in on the same as we conclude, because we're out of time. A commission with teeth, that's what we need. And the issue, can that be, akin to the same thing we're asking about credibility? And how can we detach the institution from the personalities, given the performance from previous institutions?
It's hard to detach, because the institution from the personalities running it. If the people running it appear to be weak and to be guided, then you have a problem.
Right.
Right now, the country is in trouble because there has been concerted effort to discredit the IBC. Yeah? I would disagree with the council here. I think the judgment was wrong. The one that said that because it is actually undermining the IBC. Now, the IBC itself was also right to appeal, follow the process. And the court has not pronounced itself, I mean the Supreme Court, on this matter to put it to rest once and for all. Whichever way the court decides, whether to agree with the lower court or to overturn, that will be the law. And every Kenyan, every politician in particular, is bound to go by that. What has been disturbing is that we do have prominent politicians who go around the country saying they are going to ignore the ruling.
Yeah, that's a huge red flag there.
That's a red flag automatically. They also give impression, right or wrong, that they may be preparing for commotion by doing that kind of thing. If we take the example of the primaries that we just noticed, which were disasters on both sides, where the wrong people were being declared the winners. Imagine it is done that way.